Good day, everyone. I am Rhino Veran, a second year BS Criminology student of Negros Oriental State University. So in this presentation, I am going to discuss correction, institutional correction, penology, crimes and punishment, theories of punishment, and ancient versus contemporary punishment. So this presentation is part of our fulfillment in our subject CA 200 under Mrs. Jill Rose P. Ador. So correction. It is a branch of administration of criminal justice system charged with the responsibility for the custody, supervision, and rehabilitation of the convicted offender. So, the main focus of correction is on rehabilitation and regards inmates as patients who need treatment and guidance in order for them to become productive and responsible members of the society upon their release. Proceed to the next slide. So, institutional corrections. Institutional corrections is a institutional-based correction which involves with the incarceration of criminal offenders within their legal as stated and mandated by the law. So it is a confinement facility such as jail and prison. So in institutional corrections, an individual is confined in a facility. So unlike community-based corrections, an individual is released in the society while being rehabilitated. Next slide. So, institutional correction also involves confinement of suspected persons of crime awaiting for trial and adjudication. So, adjudication means a formal judgment of the court for a crime commission of an offender, or to prove that he is guilty beyond reasonable doubt. So next slide. So penology, from the Greek words poin, which means punishment, and logos means course or study of crime prevention. So it involves prison, reformatory management, and correction of criminals. So punishment is used in order to deter criminals from recidivism or from doing bad things all over again. So, it is also a branch of criminology which deals with the management and administration of inmates. So, punishment. It is defined as the redress that the state takes against an offending member. So, it is inflicted by the group incorporate capacity in one who is regarded as a member of the same group. So it involves pain or suffering produced by this sign and justified by some value that the suffering is assumed to have. So punishment is used as a compensation to the wrongful acts of the offenders or anyone who violates the law and who is a threat to the society. So next. So it also means as means of social control. So a device to cause people to become cohesive and induce conformity. Thus, it is necessary to restore moral equilibrium for the grounds of social utility. So it also provides peace and order, because if the criminals are afraid, or if the criminals are being punished, they would be afraid to commit any crimes again. So next. So let's now proceed to the crime and the punishment. So punishment. So a term which is inherent to criminal justice. So it is within the criminal justice. So it deals with how the justice is being served to an offender and how the victims feel the justice being served. So certain acts classified as crimes. So punishment involves crimes. So the logical principle of punishment is that Sometimes it's hard to tame a barbaric as well as primitive tendencies of the public. So, in order to prevent an individual from doing the same crime again, so they tend to become harsh to those offenders. So, the punishment is used by rulers against their subjects in order to maintain fear in the minds of the public regarding the capacities and powers of their rulers. So now let's go to the theories of punishment. So there are 7 theories of punishment. So retributive, deterrent, preventive, incapacitation, compensatory, reformative, and utilitarian theory of punishment. So now let's proceed. So retributive theory of punishment is based on the doctrine of lex talionis, meaning an eye for an eye. So it requires that the offender suffer in return, so that the response to a crime is proportional to the offense. So for example, if a person is caught stealing, then in this theory of punishment, the hands used in stealing will be cut off, or the arresting officers would punish that offender. So next, so it is also retributive theory of punishment is also based on vengeance, so meaning revenge. So next, so the doctrine of societal personification and the doctrine of correctional vengeance. So in the doctrine of societal personification, when a member of the society is subjected to a very heinous crime, as a result of which the whole society, as if it were a natural person, considers the offense to be inflicted upon itself, so comes to the defense of that person either by the way of demanding justice or by conducting the same on its own. So the society is said to be personified. So in this doctrine of societal personification, each members of the society is perceiving that this certain crime is being committed to them. So in order to prevent that crime, they need to act and they need to punish. So in revenge to that criminal act. So the doctrine of correctional vengeance. So the doctrine of correctional vengeance, on the other hand, is when the society, in a fit to get justice, demands the concerned authorities to inflict vengeful, so as painful as the original act or even more so, punishments upon the victim for creating a deterrent. It is said to exhibit correctional vengeance. So the correctional vengeance is also based on the society's approach on the criminal. So next, understanding retributive theory of punishment. So first, those who commit certain kinds of wrongful acts, paradigmatically serious crimes, morally deserve to suffer a proportionate punishment. So in this it is very self-explanatory. So meaning, if you an eye for an eye, so if you committed a crime, there would be a proportionate punishment for the crime you had committed. So second, it is intrinsically or morally good, or good without reference to any other goods that might arise if some legitimate punisher gives them punishment they deserve. So, and the third is, it is morally impermissible intentionally to punish the innocent or to inflict disproportionately large punishments for the wrongdoers. Next is, it is the place where both criminal law and well as moral law meet, is the place where mostly the retributive punishments generated. So it is between the connection of criminal and the morality of humans. So that's why retributive punishment originated or are generated. So next, so the pros, let's go to the pros and cons of the retributive punishment. So pros, it is an acts as a strong deterrent. So it deters a criminal since he or she knows that if he committed this certain type of crime, there would be an equal punishment to it. So, and it helps in giving moral justice to the victim. It instills the feeling of trust within the society towards the judiciary. Because if punishment is being imposed to someone who really committed a crime, the society would be very happy and will build more trust into the judiciary system of the society. So while there are also cons, so may become disproportionate with seriousness of the crime. So sometimes the punishment being imposed is too much from the crime committed, so it may be disproportionate to the crime committed. So next, society develops the feeling of vengeance and destructive tendencies follow. So the state may become autocratic in its functioning, using the punishment to torment people. So in autocratic states where kings or leaders don't give freedom or democracy to the people, it would tend to torment and punish the people rather than to serve the punishment for who is convicted of crime. So next is the deterrent theory of punishment. So deter, which means to abstain from doing a wrongful act. So creating a fear is the objective, to set or establish an example for the individuals who or the whole society by punishing the criminal. So in this theory, it means to prevent or to deter criminal from doing wrongful acts. So the deterrent theory of punishment is utilitarian in nature. So in this quote, thou art to be hanged not for having stolen a horse, but in order that horses may not be stolen. So it is very self-explanatory that in this theory of punishment, it is done in order to protect others or to deter others from committing the same offense. So the concept of the deterrent theory can be simplifying to the researcher of philosophers such as Thomas Hobbes, Cesar Beccaria, Jeremy Bentham, and these social contract thinkers provided the foundation of modern deterrence in criminology. So they are the one of the most great factors in the deterrence in modern criminology. So next, so the three major components of deterrence. So severity, it indicates the degree of punishment. To prevent criminal law must emphasize penalties to encourage citizens to obey the law. So in severity, so on what crimes has been committed, so there is a proportionate punishment for that in order to encourage citizens to obey the law and discourage them from committing offenses. Next, the certainty, making sure that the punishments must happen whenever a criminal act is committed. So it is certain that if a person commits a crime, there would be a punishment. So Beccaria believed that if individuals know that their undesirable acts will be punished, then they will refrain from offending in the future. Next, celerity. So the punishment for any crime must be swift in order to deter crime. So the faster the punishment is awarded and imposed, it has more effect to deter crime. So very self-explanatory. So next, if punishment is severe, certain, and swift, then a rational person will measure the gain or loss before committing any crime. And as a result, the person will be deterred or stopped from violating the law. So meaning, if the punishment is severe or proportionate to the crime committed, certain, meaning there is a conviction that a punishment would be imposed, and swift, meaning the punishment is served fast, then a person would be deterred or will be stopped from violating that law. Next, the preventive theory of punishment. So, in preventive theory of punishment, it seeks to prevent prospective crimes by disabling the criminal. So, meaning or through incapacitation. So, main objective of the preventive theory is transforming the criminal either permanently or temporarily. So, in the permanently, it involves with the criminals convicted with felonies that are needed for life imprisonment or in other cases death penalty. So while in temporarily it means that the sentence of the criminal is not a life sentence, so it just takes on how many years or he or she will be released. So the preventive theory of punishment suggests that imprisonment is the best mode of crime prevention, so as it seeks to eliminate the offenders from the society. So by eliminating the offenders in the society, criminality, also the preventive theory believed that criminality would be lower since those criminal behaviors are wiped out from the society. So, and also, imprisonment as the best mode of crime prevention is a humane act of punishment since before death penalty imposed are being condemned by the human rights defenders. So now, because of the human rights, so the criminals are given a chance to rehabilitate themselves in the supervision of the correction officers. So next, the three most important ways of preventive punishment. The first is creating the fear of punishment. So by punishment, so if there would be a certainty that the punishment would be imposed, so the criminal offenders would think twice whether they commit that crime or not. So it would create fear to them since being in a prison is very irritating and you are not accustomed to the habits and the culture inside a prison, and all your what you love to do while you are in the community are being lessened or being controlled by the government since you have committed a crime. So the next is disabling the criminals permanently or temporarily from committing any other crime. So through imprisonment, the criminals are disabled from the society to create more damage in the law-abiding citizens. And the third is reformation or making them a sober citizen of the society. So as you can see in the picture, so in the first they are incarcerated, then through the prison systems, so they provide rehabilitation programs, then after that after they would be released in the society, they would become a law-abiding citizen again and they would deter from committing a crime. So next theory is the theory of incapacitation. So incapacitation is the act of making an individual incapable of committing a crime to prevent the offense by punishing through incarceration, death penalty, and etc. So preventing or restraining the danger in the future. So incapacitation and preventive theory are very they are alike to each other since they use the imprisonment as the best way to protect the citizens and to deter the criminals from committing a crime. Next, so the origin of this theory is that was originated in Britain during the 18th and the 19th centuries. So the convicted offenders were often transported to places like America and Australia. So imprisonment is considered as the best form of incapacitation. So by disabling the criminals, by their physical abilities to create danger in the society. So through imprisonment, they would be prevented from doing such crimes. So next is incapacitation through incarceration. So refers the restriction of individuals' freedom and liberties that they would normally have in the society. So by the commission of their crime, they would be deprived by their liberty and from the life that they have in the society. So next. So the purpose of the incapacitation theory is by removing sufficiently dangerous persons from the society. So this is to protect the law-abiding citizens of the society. So simply rearranges the distribution of offenders in the society. So rearranges meaning to arrange them in an order that they would not create harm to the community. So and dissuade others from the past offenders in the society. So it is the form of isolation of offenders from the society. So they are being housed in a institutional based correction where they are not allowed to go out until after serving the term of their punishment. So the application of the theory is that incapacitation gets reserved only for those who are either sentenced to prison or life imprisonment. So very self-explanatory. So next is the compensatory theory of punishment. So in this punishment theory, it is a systematic approach of providing monetary assistance in exchange for the offense. So relies on the compensation to the victim for the loss caused by the accused. So compensation theory, so for example, in a barangay, there is a misunderstanding and they would use the compensatory theory of punishment in order to settle down the complaint. So next is the victims in a crime can be compensated on two mainly grounds. So first is that a criminal who had inflicted an injury against a person or group of persons or the property must be compensated for the loss caused to the victims. And that second is the state has failed to provide safety towards its citizens must receive compensation for the loss caused. So the compensatory theory is not only applied to the citizens but also to the state who failed to protect their citizens. So for example, in a law enforcer committing a crime towards a citizen, so it is the state that would give compensation to the victim since the law enforcer is under the jurisdiction of the state. So next, compensation is the true essence of deterrent, reformative, and necessary contribution of retribution. So, reformative theory of punishment. So, the idea is hypothesis. Hypothesis meaning creating a question and trying to prove that it is right or the decision is right. So, the object of discipline ought to be the charge of the criminal offender. So, the object of order should be to accomplish the moral difference in the liable party. So, in reformative theory, the offenders are given a chance to identify the difference of morality. So, whether their actions committed are wrong or right. So, it is in the reformative theory that the prisoners are given a chance to change themselves to become better individuals. So next, so here are the basic principles of prison facilities. So applying the reformative theory as proposed by the United Nations. So first, all prisoners should be treated with respect and without discrimination or torture and other forms of ill treatment are strictly prohibited. So in this manner, the prisoners would be given a safe environment, and they would be more productive, progressive, and would think straight because they are safe, because they feel safe, and they would realize the wrong things that they have done. So next is prisons should provide a safe environment. So this is what I've said in the previous slide. So they are connected. So prisoners, visitors, and service providers. So the prison system should provide them safe environment in order for them to feel the assurance of security and safety. So while serving the term of their sentence. So next, prison life should resemble community life as much as possible in order to prepare prisoners for their social integration upon release. So in the prison, they are not only punished, but they are taught to become law-abiding citizens in order for them to cope up with the society upon the release. So next is the special needs among certain categories of prisoners are catered for in order to ensure their well-being as much as possible, their access to prison life. So those prisoners with disabilities are taken care of. So in order for them to serve the term of their punishment, and in order and it is a very humane act since um, disability is considered as a crucial part of our society, because with disability we cannot function well. That's why they are being assisted by the government. So next, so the utilitarian theory of punishment, it is to rebuff guilty parties, to debilitate, or to utilize laws to amplify the joy of the society. And the wrongdoing free society doesn't exist. The theory attempt to incur just as much discipline as is needed to forest all future violations. So in this sense, so the law is being imposed. So meaning, so to incur just and mass discipline. So in order to discipline the citizens, there must be a law that governs all. So next, so it involves punishment through deterrence, prevention, incapacitation, and reformation or rehabilitation. So they are interconnected with each other. So the utilization of different theories of punishment in accordance with the law. So by using the different theories of punishment as an approach, as a positive approach to criminality. So next, so applies the principle of law is above all and no one is above law. So it means that law is the supreme. So meaning we should not attempt to be above the law, otherwise we would be penalized. Next, the origin and history of punishment. So the oldest written penal law that stopped the ancient practice of retribution, of personal vengeance and punishment, become the responsibility of the state. So this law is known as the Code of Hammurabi, which King Hammurabi of Babylon promulgated. So before the penal law was being established, so persons the victim's family would deal the offender by themselves. So it is in the form of personal vengeance, meaning if a victim was killed, then the victim's family would gradually would gradually seek for revenge for the killing. So next. So the Code of Hammurabi is the laws compilation of the laws of the symmetric tribes. So it is written on the stone. So instituted that of the talons, meaning that state will mete out punishment equally as an eye for an eye or a tooth for a tooth. So a proportionate crime and a proportionate punishment for that crime. So next, the punishment in primitive society. So the most common punishment are in the primitive society, so in the ancient society, are death, physical torture, mutilation, branding, public humiliation, fines, forfeiture of property, banishment, and later on transportation and imprisonment. So the punishments each of the punishments are accomplished by flaying, crucifixion, beheading, impaling, drowning, and burning. Physical torture were executed by flogging, dismemberment, and starvation. Public humiliation, stocks, pillory, docking, stools, branding, and branson. And later, imprisonment was being imposed. So, dungeons, galleys, hulks, jails, house of corrections, workhouses, and penitentiaries. So, imagine before the punishment in primitive society is very brutal and inhumane, and the human rights if the human rights were present before, they would be condemning such acts, since the the criminals before are not given a chance to change themselves, but they are executed immediately in order for them to serve as an example to the public. So next, let's now go on to the ancient forms of punishment versus the contemporary forms of punishment. Let us proceed. So, the ancient forms of punishment. It could be death penalty, physical torture, social degradation, banishment, transportation and slavery, and imprisonment. So, but before, in the ancient times, imprisonment was rarely seen because death penalty, physical torture, and other forms of brutal punishments are being imposed in order to serve as an example to the public for them to deter from committing crimes and from giving them a perspective that if they would commit crimes, the government or the ruler would not give them mercy. So, the capital punishment, so also known as death penalty. So, it is a state-sanctioned practice of killing a person as a punishment of crime. So, it is made legal by the government or any forms of rulers as a punishment to a crime. So now let's proceed to minor offense. So it refers to the offenses that are less serious and with less seriousness of nature. And the punishment of it could be just a fine or imprisonment. But in the ancient times, some minor offenses could be cruelly punished through physical torture, social degradation, banishment, slavery, and imprisonment. So it all depends on the leniency of the ruler whether to give mercy on the people who committed minor offense or to impose the cruel punishments. So next slide. So here are the capital crimes in the ancient times. So it includes arson, adultery, circulating of seditious literature, denial to king's orders, forgery, homosexuality, rioting, murder, heresy, which is a contrary opinion to a religion, and piracy. So capital crimes also includes sacrilege, slave killing their masters, slave revolt, treason, and witchcraft. Next. So here are the minor offenses in the ancient times. So stealing food, letter stealing, and the stealing of livestock animals. So interaction with the audience. So here I have questions that I will answer, or you may answer in the comment box. So are ancient classification of capital crimes reasonable? In my own opinion, not all ancient classification of capital crimes are reasonable, because let us go back to the capital crimes of ancient times, the previous slide. So here, for example, adultery and homosexuality. So death penalty would be too much if it is imposed to this type of crime, since adultery can be just for imprisonment or other forms of punishment. So it's a no for me. Then the next question, is capital punishment effective? Yes, capital punishment is effective, but it creates fear rather than obedience to the law. Then next question, does the government in the ancient times practice justice and equality? In some cases, yes, though punishment imposed to serious criminals, justice is delivered. So, but in some cases, no also, because authorities tend to abuse their power and innocent people were punished because of the ruler's prejudice. So, next slide. So, these questions will be answered after we discuss the succeeding slide. So, how does capital punishment were executed for capital crimes in ancient times? So, how do they deal with minor offenses? Does their punishment deter an individual in committing crimes or offenses? So, let us proceed. So, death. Here are examples of punishment through death. So, first is flaying. Flaying is a death punishment in which a suspect is skinned alive. Then crucifixion, just like what happened to Jesus. Then beheading, impaling by piercing a sharp object to a body, to a criminal's body. Then drowning and also burning. So these punishments are very brutal if we compare it to our modern society. The next, torture. Flogging is by torturing an individual by whipping. Then pillory, by hanging an individual in a constrained wooden constrainment. Then stocks, by also it is like pillory, but it is on the wooden constrainment is on the feet of the suspect, and in this the public would throw anything at the suspect being constrained. Then branks, by the use of the metal or iron framing in the head where you cannot speak, or it is very heavy that it would create an irritating and very discomforting feeling. So next, so social degradation. So social degradation are imposed to those who committed adultery, or for some, in some instances, for bad musicians, such as like this, for example, the flute of shame. So they are imposed to bad musicians. Then the walk of shame for adultery, and also exposure for infidelity. So they impose a public humiliation to an offender who commits adultery or who is not following the norms of the society. So next, banishment is by banning a certain individual from living in that country. So from living in the country or in a certain place. So by dismemberment of a citizen from a specific tribe. The next, so transportation and slavery. So first is the racial slavery. So before, the races that are subjected to racial slavery are the Africans, since they are black, and some the Westerners consider them as low class. Then the war slavery also, and the gladiator slaves. So in the gladiator slaves, the slaves are being taught how to fight, and in order to amaze the high-ranking officials and other audiences, and it happens in Rome. So next is imprisonment through dungeons, galleys, hulks, and workhouses. So that's the forms of punishment in ancient times. So it was very cruel and inhumane. Then redress or compensation of a wrong act. So retaliation or personal vengeance. So the earliest remedy for wrong act to anyone in the primitive society. So they would retaliate, or if a certain individual attacks a family member of yours, then in the primitive society, the retaliation would be the personal vengeance, or they would seek for revenge. So that's why blood feuds before was accepted in the early primitive societies. So next, so fines as punishment. So customs has exerted effort and great force among primitive societies. So the acceptance of vengeance in form of payment. So for example, cattle, food, personal services became accepted as dictated by the tribal tradition. So if the tribal leaders or the rulers agreed that this type of offense can be settled with a fine, or a fine as a punishment, then the victim or the family of the victim could not do anything about it, since the ruler decides on what happens to the punishment. So next, so as tribal leaders, elders, and later kings become into power, they began to exert their authority on the negotiations. So wrongdoers could choose to stay away from the proceedings or trial by ordeal. So it is the most primitive way of trial. But if they refuse to abide by law imposed, they will be declared to be an outlaw. So they will be declared to be a criminal, and the tribe or the leaders would dismember the certain type of individual. Next, so here are the contemporary forms of punishment. So imprisonment, parole, probation, fine, and destierro. So compared to the ancient forms of punishment, contemporary forms of punishment are made for humane reasons. So it is imposed by the United Nations that punishments should be more humane, to give the criminals a chance to rehabilitate himself. So next, so imprisonment. So putting the offender in prison for the purpose of protecting the public from criminal activities, and at the same time rehabilitating the prisoner by requiring them to undergo institutional treatment programs. So it is the confinement of the criminals in order to separate them from the free society and to protect the law-abiding citizens. So next, So in the Philippines, there is a distinction between a jail and a prison. So a jail is a place of confinement for inmates under investigation or undergoing or serving short-term sentences. So most commonly, those who are confined in jails are awaiting for their trial. So there is no final judgment for their trials. So they are in the custody of the BJMP. So next is prison. Refers to the national prisons or penitentiaries reserved for those convicted of felonies. So those who are confined in prisons are convicted criminals, meaning the court already have given a verdict on the offender and the justice has already been delivered. Next, so jails were managed and supervised by the provincial government. So this refers to the provincial jails then. For the Bureau of Jail Management and Penology, which is under the agency of the DILG or the Department of Interior Local Government. Next, so here are the types of jail. District jails, municipal jail, city jail, and provincial jail. So there are also three types of detainees. Those who are undergoing investigation, those awaiting or undergoing trial, and those awaiting final judgment. So these types of detainees are subjected to jail rather than prison. So next, so district jail. It is a cluster of small jails, each having a monthly average population of 10 or less inmates and is located in the vicinity of the court. So it is located near the court in order for the court to propose hearings. Next, so some prisoners are held in district jails if their court hearings are forthcoming. So if the hearings are forthcoming, they would be transferred to a district jail a day before or even a week before the hearing to prevent any delays. Next, so municipal jail. So it is a lock-up, police station, or other place maintained by a municipality for the detention of suspects or offenders. So it is a local jail found in the municipality. So next, municipal prisoners are one who are sentenced to a prison term of 1 day to 6 months. So city jail, it is an institution for detention of the suspects or offenders. So usually have higher populations compared to the municipal jail. Next slide. So the city jail prisoners are sentenced to a prison term of 1 day to 3 years. Next, the provincial jail, an institution for the detention and incarceration of convicted criminals. So, place where criminal offenders of the province were held in custody. So, provincial prisoners are one who is sentenced to prison term of 6 months and 1 day to 3 years. The next, prisons were managed and supervised by the Bureau of Corrections and agency under the Department of Justice. So, jails and prisons are similar but they have this distinction. So, jails are supervised by the BJMP under the DILG, while the prisons were supervised under the Bucor, which is an agency under the Department of Justice. So next, so prisons also known as penal institutions. So building where people convicted of a serious crime are kept as a punishment for their crime, and also as an isolation of criminal offenders to protect the citizens of the society. So let's proceed to the next slide. So, insular or national prisoners. So, these prisoners are who are sentenced to a prison term of 3 years and 1 day to death. So, national prisoners or insular prisoners are those who committed serious crimes or felonies such as murder, rape, and etc. Next, so the New Bilibid prison in Muntinlupa is an example of an insular prison or a national penitentiary. So it is located in Muntinlupa, Metro Manila, and is the main insular penitentiary designed to house the prison population of the Philippines. So next type of punishment is through parole. So it is a condition release of a prisoner after serving of his or her sentence in prison for the purpose of gradually reintroducing him or her to free life under the guidance and supervision of a parole officer. So parole is under the community-based correction. So I will not explain it further since it is very self-explanatory. So, the Board of Pardons and Parole, or the BPP, and the Board of Pardons and Parole was created pursuant to the Act 4103. So, it is an act to provide for an intermediate sentence and parole for all persons convicted of certain crimes. So, next slide. So, functions of the BPP. So, it is to grant parole to qualified prisoners. So, to recommend to the President the grant of pardon and other forms of executive clemency. So, to authorize the transfer of residence of parolees and pardonees, or order their arrest and recommitment, or grant their final release and discharge. So, if the prisoners are found with right conduct serving their while serving their punishment, so the Board of Parole can recommend them to executive clemency. So next, the basis for grant of parole. So the person is fit to be released. So the person is fully treated and he has no signs of a criminal behavior anymore. Then there is a reasonable probability that if released, or he or she will live and remain at liberty without violating the law. So deterrent to criminal acts. So next, his or her release will not be incompatible with the welfare of the society. So upon his or her release, it should not contribute negatively to the society. Next, the BPP provides invaluable assistance to the President in exercising the power of executive clemency. So it is exercised with the objective of preventing miscarriage of justice or correcting a manifest injustice. So, executive clemency may be exercised through a reprieve, absolute pardon, conditional pardon, or commutation of sentence. So, here are the definition of terms. So, reprieve is to cancel or postpone any punishment, while absolute pardon is the total extinction of the criminal liability resulting to the full restoration of his or her civil rights, meaning the criminal or the convicted criminal can be reintegrated back into the society. The next is the conditional pardon. Depends on the fulfillment of a condition by the offender. So, if he is proven with the right conduct while serving his or her sentence, then he can be subjected to conditional pardon. Then the commutation of sentence, it is the reduction of the time sentence of a criminal. Next is probation, a privilege granted by the court to a person convicted of a criminal offense to remain in the community instead of actually going to prison or jail. So this type of punishment is also based on the community-based corrections. So next, a disposition whereby a defendant after conviction of an offense, the penalty of which does not exist, 6 years imprisonment, is released subject to the conditions imposed by the releasing court and under the supervision of a probation officer. So even though they are released back to the community, they are still being monitored and supervised by the probation officer to determine whether they are not violating any laws. Next is fine. So this is a form of monetary punishment, a crime or offense committed. So common in criminal law context. So fines are used in instances involving minor crimes such as traffic violations. So these fines are imposed to minor crimes only. Then for instance, a person who exceeds a driving speed limit is subjected to a fine. Other instances include settlement of claims against the accused person. So example, there is a feud in a barangay, then if the barangay captain could settle it within the victim and the within the offended party and the offender through a form of fine or a compensation. The next is destierro. It is the banishment or only a prohibition from residing within the radius of 25 kilometers from the actual residence of the accused for specified length of time. So while it is technically not imprisonment, it is still a penalty imposed under the revised penal code of the Philippines. So destierro is also a type of community-based correction where a certain individual is not allowed to go near a person where he committed an offense. So that's all. So any questions, suggestions, or clarifications, you can comment it in the comment box. So thank you for watching and listening to my presentation. Once again, I am Rhino A. Veran. Have a good day.